Bon après-midi, chers auditeurs.
Good afternoon, dear auditors, ladies and gentlemen, President, Secretary General, and my dear colleague from the court, Judge Salam. It is a real pleasure to meet you today to deliver this lecture on the course of the World Court, its trajectory on the eve of the first centenary of this creation, the creation of the first permanent court of a general nature. It is also a pleasure for me because 31 years ago, in 1988, I was too an auditor at this academy, just like you are today. And not for a moment could I then imagine at the time that I would be coming back, not so much at the academy, but before the International Court of Justice as the agent of a new state, Slovakia, in the case between this country and Hungary in the Gabčíkovo-Nagy case. I couldn't have dreamt that 14 years later, member states of the United Nations would then elect me to sit on the Tribunal Suprême, the highest possible court. If I may use the turn or the phrase, we coined the phrase, I'm referring to Alain Pelé, the French consul before the court. It's difficult for me to imagine a better opportunity to come back before you and to speak about the origins and the trajectory of the century of the first Paris conference. 99 years ago, a major transformation took place. We moved from optional arbitration to a permanent court. And that process was actually launched here in The Hague. It happened at the conferences of 1899 and 1907. And once again, it is here in The Hague that the Committee of Jurists or lawyers met here in 1920 in order to start drafting the future statute of the Court of Justice, the Permanent Court of Justice. And I think it can be said that this process has really been marked by its presence in this city, which used to be called the Mooistaat achter de Duinen, in other words, the pretty city behind the news. Nowadays, of course, The Hague is better known as the International City of Peace, of Justice, or if you want to use a different concept, a different image for the city, coined by the former Secretary General of the United Nations, former member of the Curatorium, and President of the Curatorium, Mr. Boutros Ghali. He called The Hague the legal capital of the world. But the Dutch people decided to slightly tweak that name, and they're very proud to be able to refer to The Hague as the legal capital of the world. Indeed, the first point on which the Committee of Jurists meeting in 1920 were able to agree on was that the headquarters of the court would be situated here in The Hague. So this is the opportunity for me to remind you of something said by Léon Bourgeois, a lawyer, at a French statement, the first president of the Assembly of the League of Nations, and furthermore, a Nobel Peace Prize laureate, or winner, in 1920, on the occasion at the opening of the session of the Committee of Jurists of Lawyers. When Mr. Bourgeois gave his lecture at the beginning of the opening session, he observed as follows: international life is developing every day, and this intensity of development is not something that anyone could possibly have foreseen a century ago. Now, 100 of years down the road from the Paris Peace Conference, I'm just wondering, what would Mr. Bourgeois say about the century that has just elapsed? And what would the future generations think of us today when they look back towards us in a century's time? As to the second question, I'm not going to attempt to answer it. And yet, what I would like to do is make perhaps a few observations concerning the former questions. The first question, that is to say, could Mr. Bourgeois actually anticipate these developments in the area of international justice in 20th century? And would these developments have actually been up to the expectations, the hopes, the desires of those who were first set the foundation for this process? It's very difficult to measure the progress of international justice in centuries, but generally it proves not only its existence, but also its resilience, its staying power. Thanks to the travaux préparatoires of a statute of the Permanent Council, we can, to some extent, piece together the beginnings of the work done on this permanent international form of justice. Those who drafted the statute in 1920 and also the attempts at drafting a text prior to that. But in order to really fully understand the importance of events in 1920, I would like to look back further, a century before. I'm referring here to the year 1819. Would it be possible to believe that there would be one day a permanent international court, a forum where interstate disputes would be resolved in accordance with international law? Historians know full well that in 1815, after a series of wars, that the European powers came together for another conference in order to lay down the foundations for a new international public order. If you look at the final act of the Vienna Congress, you see that the participants at that Congress had a very different of what the results might be obtained through multilateral negotiation as compared to what they thought in 1919 or as compared to what we know today. Most of the discussions at that Congress had to do with the dividing up or territories of European powers following the defeat of Napoleon. Some of the discussions actually dealt with the reparations to be paid by France. Now, this is really a sharp contrast with other cases like the most recent one, armed activities on the territory of the Congo, Democratic Republic of the Congo versus Uganda, that the court will decide soon. We expected the hearing to take place in November. It's a striking difference for two reasons. I would say, first of all, because this is a court of justice that will settle the matter. It's not a diplomatic conference. Secondly, and this is the immediate consequence, the first reason, because it raises the question of applicable law. Clearly, the law applied by the court is very different indeed from the types of solutions that ambassadors and ministers relied upon in Vienna some 200 years ago. The 19th century has seen a real growth in interstate arbitration, sometimes provisions that provide arbitration is part of multilateral agreements. For instance, Article 16 of the Universal Postal Convention of 1874. So towards the end of the 19th century, we saw the development of international arbitration. In 1899 in The Hague, with the first peace conference convened by the Russian Tsar, Nicholas II, we wanted to deal with two subjects in particular. First of all, he wanted to look at the possible solutions to reduce military budgets through the acceptance of a disarmament mechanism, because it was an increasing burden for major European empires, industrial empires. And the second objective was to strengthen peaceful dispute settlement mechanisms, in particular by resorting through arbitration. Already back then, in 1899, the international community had thought about the creation of a new institution, a new arbitration system. Their main purpose, was to create a genuine international tribunal to settle international disputes. Now, the creation of the Permanent Court of Arbitration is a milestone in that regard, in the institutionalization of international justice, as we call it today. Now, the creation of the Permanent Court Arbitration was a milestone in this regard. The Arbitration has 123 states parties that have signed to either one or both of its founding conventions. Nevertheless, even at the conference of 1907, states were aware of the fact that the Permanent Court of Arbitration wouldn't be the last link in the chain of development of international justice. For instance, at the Second Peace Conference in 1907, the representative of the United States, Joseph Hodges Coates, let me quote here, because in English, with a translation into French, rien de permanent, de continu, rien de pas de connexité dans les séances de la Cour ou dans le traitement des affaires portées devant elle. Ceci a été une évidence source de la faiblesse, de l'absence de prestige de cette juridiction. Toute procédure dont elle avait la charge constituait un tout indépendant, et ses prononcés, rares, temporellement très éloignés les uns des autres et déconnectés quant à l'objet, ne constituaient certainement pas un corpus cohérent de droit international, tel qu'on peut en attendre d'un tribunal international, censé représenter le pouvoir et la puissance de toutes les nations. Fin de citation. I think we shouldn't think or see things in a deterministic way. We should focus on the question raised by this process. Incidentally, the process is not fully achieved. It's not completed yet, and the questions that were raised 100 years ago are still topical to this very day, as we shall see in a few moments. In particular, Mr. Coates' observations do flag up to three attributes. These three attributes that are the characteristics of a genuine international court. Permanence is one, a constant case law or consistent case law, and universality being the third one. Back in 1919, the powers, be they large power or small powers, but this time they weren't just talking about European powers. These powers met again, came together in Paris and then in Versailles for the signature, to to shape the future international relations. The Paris Peace Conference was something of a novelty in terms of international relations, it can be said. On the agenda of the conference, you found not only territorial adjustments or war reparations, which had been tackled in Vienna a century earlier, but also, in addition to that, the question of an international organization with a general jurisdiction. Indeed, and this is quite interesting to know, the first draft of the Pact of Covenant of the League of Nations discussed by states did not actually refer to the creation of a court, or they were extremely vague in that draft. There was a British draft prepared before the conference. There were also a draft prepared by President Wilson of the US. They included a general provision on arbitration of disputes and hinted at the possibility of settling disputes or even arbitral settlements. In fact, the British draft talked about the settling a dispute by way of arbitration, whereas the Wilson project, or the Wilson draft, it was called, was a general provision. In January 1919, during the conference, the British American representatives agreed that they would include a general provision that referred to the creation of a permanent court. And that idea was then also taken on board by the legal advisors of the UK, in particular Sir Cecil Hurst, who then became a judge at the Permanent Court of International Justice, and later he became the president at that court. And also, it was taken on board by the President Wilson and his counsel advisor, David Hunter Miller. They served, in fact, to draw up a project for the Permanent Court of Justice. The rest of the provisions has to do with the jurisdiction of the court, which was limited to dispute of international nature, in other words, interstate disputes, that parties would submit to the court. Furthermore, it also provided for an advisory or consultative jurisdiction for any dispute on any point brought to it by the Council or by the Assembly. Now, in order to fulfill this mission, the Council decided to set up a committee of international jurists and mandated them to prepare a preliminary draft. There were 10 members on the committee. Most of them subsequently became members of the court. The Secretary General of the League to the committee, Professor Dionisio Ancelotti, the Deputy Secretary General of the League, and Hake Amakchold, Legation Secretary and member of the Secretary of League. He would be the Deputy Secretary. He was a young Swedish jurist, the brother of Dag Hammarskjöld, who subsequently became the Secretary General of the United Nations, very much better known on the international stage than his brother Dag, as he served not only Secretary Registrar of the Permanent Court of International Justice. Following an invitation by the government of the Netherlands, the government then held its session in the Peace Palace in The Hague, which was already the headquarters of the Permanent Court of Arbitration, between the 16th of June and the 24th of July 1920. There were 35 sessions in total were held, and they were able to prepare a draft. There were debates within the committee. These debates show that all the questions which we take for granted, which considered to be general principle of international judicial function back then, were not quite so obvious. There were very lively discussions. And this, thanks to the advisory committee, the opinions expressed the member of the committee were decisive when it comes to the functioning of the permanent court. The work of the Committee of Legal Experts were, of course, influenced by previous drafts and previous projects, particularly by the 1899 and 1907 Hague Conference. And they were also influenced by the first Five Powers project, which were drawn up by the conference held in The Hague in February 1920. A close scrutiny of the historical development on this issue, the way in which the drafting of the statute was done, will lead you to understand that a lot of the provisions were inspired by previous drafts. However, there are many novelties, novel features. And don't forget that their work is really at the origin of the statute of the International Court of Justice. I think it would be difficult, while not impossible, to outline for you in a few minutes the very lively discussion that took place over a whole month, or more than a month. The debates were very lively, sometimes a bit too lively. More lively in any case that some of its members would have liked. There were a number of clashes in the debates from the outside concerning the election of the president of the committee of legal experts. Sometimes, it happens even in international conference, there are clashes until the end of the debate on the compulsory jurisdiction. Little by little, members of the committee really started to realize that all the important questions that they wanted to address were actually connected, and that therefore the choices had to be consistent. The election of the judge has to do with the profile of the judges, the qualities, the skills required from judges at the court. In order to operate as well as possible, international court must guarantee the consistency of its case law. The first substantive issue that was raised back then, and one of the most dedicated that the Committee of Legal Experts has to tackle, was the election of judges. The 1907 conference was not able to find a solution to this matter, and that was perhaps the reason why it failed in 1907. The principle of sovereign equality implied that the large powers had to face up to the situation, even though they wanted to benefit from the preferential treatment. Eventually, the draft of Elihu Root won the day. He was the former Secretary of State from the United States, and this draft mentioned the idea of a bicameral decision that would actually apply or draw upon the political bodies of the League of Nations. The solution was surrealistic, and the members of the court are still being elected both by the General Assembly and by the UN Security Council. Then the committee had to address the skill set required by future members of the court. For instance, is it possible for a national domestic judge without any international experience? Is it possible for that judge to become a good international judge? If you look at the minutes of these sessions, you will see that there was a certain degree of intellectual provocation. For instance, on discussions regarding the incompatibility of functions, Lord Phillimer, who was the UK delegate to the committee, said it would actually be better for an international judge to also belong to the a magistrature of his own country. Of course, he was thinking about the British situation. He was thinking of the Law Lords. Now, and that opinion was supported by most of his colleagues. The next day, on the issue of jurisdiction, the future president of the court, a Dutchman, Mr. Loder, as well as Procédure de la Pradelle, the French expert, said that it would be appropriate for there to be a right of individual petition for individuals to be able to access the court. And indeed, they provided that French were the only official language at the court. It was only at the Assembly of the League of Nations that English was added as the second language of the court. Finally, and perhaps most interesting, the committee, the majority of members of the committee was in favor of the compulsory jurisdiction of the court. And that decision was arrived at after lengthy legal reasoning. And once again, it's interesting to note that just a few days before the end of the session, the committee was debating on two drafts concerning the organization of the conferences for the development of international law and on the creation of a High Court of Justice that would be mandated to adjudicate crimes against universal rights. As to the first proposal, the members of the committee were aware of how important it would be to little by little develop and codify international law that would then be applied by the court. Finally, there was a third resolution suggested by Mr. Loder, the Dutch member, that dealt with the establishment of an international academy of international law. And you are the auditors of the Academy of International Law today. So Mr. Loder back then suggested in his resolution that reads as follows. The advisory committee of legal experts meeting in The Hague in order to draft the statute for the Permanent Court of International Justice would like to take this opportunity to express the wish that the Academy of International Law created in The Hague in 1913, I'm not sure whether it was actually 1913 or 1914, but it doesn't matter, the operations of which were suspended because of the events, in other words, the First World War, that it would be allowed to resume its activity as soon as possible alongside the Permanent Court of Arbitration and alongside the Permanent Court of International Justice in the Peace Palace. The Committee of Legal Experts talked about the cohabitation. 3 institutions would be located here in the Peace Palace: the Permanent Court of Arbitration, the Permanent Court of International Justice, and the Academy of International Law. And that's when the Academy started its operations in 1923 with the first summer courses. So one clearly sees the historical bonds, the links that exist between the International Court or courts and the Academy. As to the jurisdiction of the court, it was intimately linked to that of applicable law. The members of the committee were aware that compulsory jurisdiction implies that court would actually decide or determine the applicable law. And there was a risk of judicial or judge-made law or judicial lawmaking. And therefore, some general principles were drawn up in order to prevent the risk of non-liquid. The last major issue debated by the committee was compulsory jurisdiction of the court, and debates were marked in particular by the opposition expressed by the Japanese member Mineichiro Adacho, who in 1930 was elected as a judge to the court and simply became its president. Mineichiro Adachi recalled the French adage, the dictum, in these debates on the compulsory jurisdiction of the court. Mineichiro Adachi, grasp all, lose all. Eventually, the committee issued a recommendation, namely that there be compulsory jurisdiction be given to the court. The committee adopted a unanimously preliminary draft of 62 articles. There were exceptions. Reservations were expressed by Judge Adachi and by Ricci Bussati. Then in October 1920, the draft was examined and amended by the Council. The Council spoke against compulsory jurisdiction for the Permanent Court of International Justice. That's, of course, due to the fact the great powers didn't want to be subjected to the compulsory jurisdiction of the court. The Council introduced a provision on dissenting opinions and introduced a provision following a proposal of the British delegation, namely that the decision of the court shall only be binding of the parties to the disputes and in the case before it. And this is what you find reflected in Article 59 of the Statute of the Court. Then the draft was sent back to the Assembly, and oddly enough, if you look at the membership of the Third Commission, half of them had also been members of the Advisory Committee. This time they were there as state representatives. The main discussion within the Third Commission dealt with 3 points, 3 aspects, primarily the election of judges, compulsory jurisdiction, and the relationship between the court and the League of Nations. The committee had suggested that the elections should be held every 9 years. The Assembly, however, was criticized by the judges Hurst and Fromageau, who were worried about the lack of continuity of the court's case law. However, the proposals were not accepted, and it's only in 1946, with the creation of the International Court of Justice, that election took place every third year in order to combine continuity with renewal in terms of the membership of the court, and to make sure that there will be a good enough continuity in the caseload of the court. But the most thorny problem with the compulsory jurisdiction, the most important question for discussion, and in this discussion concerning the statute, that the Brazilian member, Fernandes, who sat on the committee of legal experts, suggested that we add what has become Article 36, paragraph 2, which is the optional clause on compulsory jurisdiction. As to the adoption of the statute, Article 14 of the Covenant said the draft would be presented to the member states, and according to the domestic legislation of some member states, that would actually mean separate ratification domestically. In other words, an international treaty had to be adopted first, and an assembly resolution did not suffice in that regard. Furthermore, some states were not members of the League of Nations back then, particularly the United States of America. A resolution coming from the Assembly would make it more difficult for them to join in, since according to the Covenant, there was no provision made for non-member states taking part in sessions or voting on text within the Assembly. A number of suggestions were made back then, and the subcommittee of the Third Commission then approved a draft resolution tabled by Mr. Fromageau, who suggested adoption of a resolution by the Assembly, as well as opening a protocol for signature. In that debate, it was explained that the vote of the Assembly would lead to the creation of the court as a body of the League of Nations, whether the competence of the court or jurisdiction would be ratione persona should be determined through state ratification. On the 13th of December 1920, the Assembly adopted a resolution concerning the establishment of a permanent court of international justice and its statute. And in a separate instrument, the protocol for signature provision was made for acceptance of the statute by the states. The protocol then entered into force in 1921, and the Second Assembly of the League of Nations were thus in a position to elect judges in September 1921, and that's when the court began its work on the 15th of February 1922.
The Permanent Court of International Justice was, in fact, if I may say, an instant hit. Speaking to American professors on international relations in August 1926, Arthur Hammarskjöld, the first registrar of the court, whom I already mentioned, reported that in its first 4 years, the court had heard as many cases as the Permanent Court of Arbitration had seen in its first 25 years. Of these cases, 7 were contentious cases and 13 requests for advisory opinions. The willingness of states, both in the bilateral relations and through the political organs of the League of Nations, to bring questions to the court for resolution or advice in accordance with international law, reflects the enthusiasm for the idea of international judicial dispute settlement. This enthusiasm presented the Permanent Court with the opportunity to show the value of its continuing character through the development of consistent case law. At its beginning, the Permanent Court was well aware of the weight of this task. For example, during the elaboration of the rules of court, its first president, Mr. Loder, remarked that it was the duty of the court to build up international jurisprudence. The novelty of the court's mandate was not lost on its members, and serious thought was given to every aspect of how to perform it. In one historical study of the Permanent Court, for example, Professor Ole Spearman recounts the internal debates concerning what judges should wear. By a close decision of 6 votes to 5, the Permanent Court decided that judges would have robes. This distinguishes judges from arbitrators and also reflects judicial nature of the court, as judges in a national jurisdiction, in principle, were judicial robes. While such question may at first strike one as petty, they do have significance. The ultimate emergence of a practice of judges wearing uniform attire, separately from their particular national traditions, serves as a visual reminder of the international nature of their function and the universal aspirations of international justice. Among the Permanent Court's more noteworthy early decisions were naturally also judicial decisions, a few of which I shall now touch upon. In its very first contentious case, SS Wimbledon, the Permanent Court addressed the relation between state sovereignty and the conclusion of treaties. The case concerned passage through the Kiel Canal, which links the North and Baltic Seas through German territory, of a shipment of arms destined to support Poland, which was in a state of war against the nascent Soviet Union, in which Germany had declared itself neutral. Under the Versailles Treaty, the Kiel Canal was to, and I quote, remain free and open to vessels of commerce and of war of all nations at peace with Germany on terms of entire equality. End of quote. Germany contended, however, that its obligations in respect of passage through the canal could not deprive it of its sovereign rights as a neutral power, and that it could not be required to permit the passage of contraband across its territory. The court explained that it did not see in the conclusion of any treaty by which a state undertakes to perform or refrain from performing a particular act an abandonment of its sovereignty. Continuing with its now well-known dictum that the right of entering into international engagements is an attribute of state sovereignty. Because Germany's rights as a neutral power accordingly did not relieve it from its obligations under the Versailles Treaty, the court found that German authorities were wrong in blocking the ship's passage. The Mavromatis case, the Permanent Court's second contentious case, is another good example in this respect. The Permanent Court's judgments, first 1924 judgment on preliminary objections in Mavromatis Palestine concessions, and 1925 merits judgment in the same case, concerned separate phases. At the heart of the dispute was a conflict between the two investors' rights to concessions in Palestine. Mavromatis, a Greek national, claimed rights under pre-war agreements with the Ottoman Empire, while the United Kingdom, as the post-war mandatory power of Palestine, awarded conflicting rights to another investor. At the merits phase, the court determined that one of Mavromatis' concessions remained valid, and that the existence of conflicting rights in favor of the other investor were inconsistent with Britain's obligations as mandatory power. However, the Permanent Court's preliminary objections judgment in this case, Mavromatis Palestine concessions, remains of particular continuing relevance today in several respects. For example, the court's legal analysis of its jurisdiction in that case begins with elegant and oft-quoted dictum. And I quote, A dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons. End of quote. This sentence has been recalled in 5 judgments of the court in the present decade alone, since 2011. As the existence of a dispute remains a necessary condition for the jurisdiction of the court, according to the views of the majority, or some judges for the exercise of the court's jurisdiction. The case is also considered a cornerstone of the law of diplomatic protection, and the court has relied upon it in further cases in that respect as well. It was not only in its early years that the Permanent Court contributed to international jurisprudence. What is perhaps the most significant of its judgment, the one handed down in 1927 in the Lotus case. That judgment was adopted by a casting vote of President Huber from Switzerland. Lotus concerned a collision between a French ship and a Turkish ship on the high seas near the island of Lesbos. When the French ship came to port in Istanbul, the Turkish authorities arrested the French officer in charge at the time of collision and put him on trial. The case before the court concerned whether this was consistent with international law. The court famously analyzed whether international law contained an obligation that would prevent Turkey from doing so. And the court reasoned, and I quote, "International law governs relations between independent states. The rules of law binding upon states therefore emanate from their own free will as expressed in conventions or by usages generally accepted as expressing principles of law and established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims. Restrictions upon the independence of states cannot therefore be presumed." End of quote. Accordingly, the Permanent Court could not see a rule prohibiting Turkey from exercising jurisdiction and therefore concluded that Turkey had not acted inconsistently with international law. While the outcome of Lotus is of no lasting importance, the court's famous dictum continues to resound in international legal arguments even today. Indeed, Lotus is one only of a handful of cases which has lent its name to the proposition for which it is famous. In this case, the so-called Lotus principle. One interesting aspect of the Permanent Court's judicial activity is the importance of its advisory jurisdiction. As I have mentioned previously, Article 14 of the League Covenant succinctly provided that the Permanent Court could give an advisory opinion upon any dispute or question referred to it by the Council or by the Assembly, giving the Court an important role in the machinery of multilateralism. At first, the idea that an international judicial organ could have an advisory function was controversial. A French commentator in the 30s described its inclusion as a bizarrerie. Many were concerned that the power to give advisory opinion would detract from the court's judicial character. However, as a professor at Harvard Law School, Manly Hudson, remarked in 1925 opinion in the New York Times, he became judge of the Permanent Court 10 years later. Few foresaw the great service to be performed by the court in giving advisory opinions to the Council of the League of Nations. Indeed, the advisory jurisdiction of the Permanent Court would become well used, occasionally in cases with a high political significance. A clear example of this is the court's advisory opinion on the customs regime between Germany and Austria. At the end of the First World War, it was saw that Austria's independence was essential to general peace in Europe. Accordingly, Article 88 of the Treaty of Saint-Germain made Austria's independence, and I quote, inalienable otherwise than with the consent of the Council of the League, end of quote. In a further protocol between Austria and certain other European powers, Austria also committed to abstain from any economic or financial engagement calculated directly or indirectly to compromise this independence, and from granting to any state a special regime or exclusive advantages calculated to threaten this independence. When Austria entered a customs union with Germany without first seeking the consent of the League's Council of the League of Nations, the Council requested an advisory opinion on whether this was consistent with the Treaty of Saint-Germain and the Protocol. The Permanent Court was sharply divided, and the case was decided by a vote of 8-7. With regard to the alienation of its independence, Austria's independence, the court concluded, consistently with its judgment in SS Wimbledon, that the establishment of a custom union did not violate Article 88 because it does not in itself constitute an act alienating Austria's independence. The court instead concluded that an Austro-German customs union entailed a special regime calculated to threat its independence that would violate the latter protocol. These conclusions obscured the scope of divisions on the court, as only one judge agreed with both of the conclusions. In a joint declaration and individual opinion, 6 of the judges, agreeing that customs union violated the protocol, have expressed the view that Article 8 they expressed the view that the union also violated Article 88 because it either alienated or was calculated to alienate Austria's independence. And in retrospect, taking into account historical developments in the 30s, we can see how correct these judges were as far as the threat to Austria's independence through the conclusion of this custom union. Compared to the present court, the Permanent Court's advisory caseload was much heavier. In its 18 years of activity between 1922 and early 1940, the Permanent Court gave 27 advisory opinions. It was only last February that the present court, functioning since 1946, matched this record with its Chagos advisory opinion, taking thus over 4 times as many years to get there. But this is not to criticize the court. This rather reflects the situation that, in contrast with the Council of the League of Nations, the Security Council of the United Nations does not consider necessary to seek advice from its principal judicial organ of the United Nations, since the Security Council requested advisory opinion from the current court only once concerning Namibia, which was granted in 1971. This record of the Permanent Court of International Justice in exercise of its advisory function is even more remarkable given the relatively limited scope of the jurisdiction. Under both Article 14 of the League Covenant, and originally advisory function was not regulated by the statute of the Permanent Court, but provisions were added only when the statute was revised in 1929. Only the League Council or the League Assembly were entitled to request advisory opinions. By contrast, 16 organizations of the UN system, in addition to the United Nations, General Assembly, Security Council, ECOSOC, are authorized under Article 96, paragraph 2 of the UN Charter to submit a request for advisory opinion. One interesting contrast is that while 4 of the Permanent Court's advisory opinions relate to the institutional law of the International Labour Organization, International Labour Organization has requested none in its own right from the present court. In total, the Permanent Court existed for formally 25 years, but functioned only for some less than 19 years, since 1922 until early 1940. And while hearings were planned for mid-May in a case between Belgium and Bulgaria relating to Electricity Sofia company, the holding of those hearings was prevented by Third Reich's invasion of Netherlands on 10 of May 1940. During these less than 19 years of activities across 65 proceedings, the Permanent Court produced 32 judgments, 27 advisory opinions, and 137 orders, mostly on time limits procedural orders. That we remember and return to these cases is a testament to early successes of the Permanent Court to work towards the jurisprudence constante that eluded the earlier tribunals of the Permanent Court of Arbitration. The Permanent Court was not to last forever, but its legacy would indeed be permanent. During the Second World War, the Permanent Court heard no cases. Early on in discussions of post-war fate of the Permanent Court, it was agreed that whatever World Court would exist should have significant continuity with the Permanent Court. It was agreed at the Dumbarton Oaks, when the preparations were done for the creation of the United Nations organization, that the court would be an organ of the United Nations in contrast to the status of the Permanent Court. These principles are now enshrined in the United Nations Charter, and Article 91 makes it clear both that the International Court of Justice is the principal judicial organ of the UN and that its statute is based on that of the Permanent Court. These two decisions had important consequences for the future of the court and its success as a truly international forum for the settlement of disputes. On the one hand, the tradition of the Permanent Court would be maintained. The present court is very much the successor of the Permanent Court, and its jurisprudence continues to guide our work today. The continuity of the present court with the Permanent Court also finds expression in Article 36, paragraph 5 of the statute, which provides for the survival of declarations recognizing as compulsory the jurisdiction of the Permanent Court and for the application to the International Court of Justice. At the same time, being an organ of the United Nations expands the reach and legitimacy of the court. As Article 93, paragraph 1 of the Charter makes clear, all members of the United Nations are ipso facto parties to the statute of the court. Thus, the problem, for example, the executive branch in the United States was never able to convince the US Senate to join the statute of the Permanent Court, was eliminated. Acceptance of this existence of, but not jurisdiction of the World Court became an integral part of the package of multilateralism. Accordingly, nearly all states are now parties to the statute of the court, as nearly all states are members of the United Nations. Additionally, the court is open pursuant to Article 35, paragraph 2 of its statute and Resolution 9 of the United Nations Security Council to states which are not members of the United Nations that, and I quote, deposit with registrar of the court a declaration by which they accept the jurisdiction of the court in accordance with the Charter of the United Nations and with the terms and subject to the conditions of the statute and rules of the court, and undertake to comply in good faith with the decisions of the court and to accept all obligations of a member of the United Nations under Article 94 of the Charter. Such a declaration was the basis for jurisdiction in court's first contentious case, the famous Corfu Channel case. There is currently one case pending before the court brought on the basis of such a declaration. The case is called the Relocation of the United States Embassy to Jerusalem, and was brought by the State of Palestine, which is not a member state of the United Nations, thus party to the Charter of the United Nations and the court statute, but was granted by the General Assembly the status of the observer state in the United Nations, in the General Assembly. The United States informed the court that in the views of its government, the court manifestly lacks jurisdiction. The court, in accordance with rules of court, decided that the question of its jurisdiction and the admissibility of Palestine application shall be determined separately in, I would say, liminalities. Palestine filed its memorial on these issues in mid-May, and the United States may submit country memorial by mid-November. So the case is pending, and we have to wait what is going to be the decision of the court, and I cannot comment any more on the case if I do not wish to be eliminated from its consideration. In order to give you opportunity to ask questions, I think I will have to shorten my presentation, and I will only briefly speak about more than 70 years of activities of the court. I can say that in the first 2 decades, the reconstituted World Court was successful. Although the first 15 members of the court were elected on 6 February 1946 at the first General Assembly of the United Nations held in London, and this explains why the term of office of members of the court starts on 6th of February, those elected in regular elections. And the judges were sworn in April 1946. The court started its real judicial activities, leaving aside elaboration and adoption of the rules of court, which are based on the rules of court of the previous Permanent Court of International Justice. So the court started its real judicial activities in 1947, when it was seized with its first contentious case, Corfu Channel. In fact, this was indeed a very good beginning for the court. The principal decision of the court about the legal position of international straits, elaborated in that judgment, was adopted as a conventional rule in Article 16 of the 1958 Geneva Convention on the Territorial Sea and the Contiguous Zone. Bolder, but very influential, was the judgment in another maritime matter, the Norwegian fisheries case. This, in effect, changed the law as it had hitherto been widely understood to be, concerning the extent and boundaries of national internal waters, thus also pushing out the baselines of territorial waters. The court seems to have been persuaded by the west coast of Norway deeply indented and cut into and with a fringe of islands, was geographically a most unusual coast. It was a curious irony that the geography of the Norwegian coast was parallel by the west coast of Scotland, to which a like regime was later applied by the claimant, in this case, the United Kingdom. So, in fact, the United Kingdom originally objected. Once the court decided, applied the similar rule as far as the coast of Scotland is concerned. The court's decision was not very much popular with the maritime powers, but it was nevertheless quickly generally accepted and was to receive its final imprimatur in the adoption as Article 4 of the 1958 Convention on Territorial Sea, which was in 1982 incorporated into the new United Nations Convention on the Law of the Sea. Another interesting case during this period decided by the court was the monetary gold case, which arose from an attempt by the United Kingdom to attach gold belonging to Albania, but lodged with the applicant Italy in order to use it to satisfy the damages awarded by the court in the Corfu Channel case. The court found that it could not adjudicate the claims, but so found in a very technical and complicated way, which inspired much comment. The principle enunciated by the court in that case is still much invoked in the court's litigation. And the principle says that the court cannot adjudicate a claim when the legal interests of a third state, not before the court, would form the very subject matter of the decision, more exacting threshold than the third state's interest being affected. The conclusion is based on the principle that the court can only exercise jurisdiction over a state with its consent. During this period of its existence, the court was also much occupied with requests for advisory opinions. These included 2 opinions on the admission of states to the UN, an important opinion on reservations to the Genocide Convention, no fewer than 3 opinions on various aspects of the South Africa question, 2 opinions on the interpretation of the peace treaties with Bulgaria, Hungary, and Romania. Of great and lasting importance was the extremely important advisory opinion on the reparation for injuries suffered in the service of the United Nations. The question was whether the United Nations was competent in international law to bring a claim concerning an individual who was assassinated whilst acting as an agent of the United Nations. The opinion in effect determined the direction in which international law was to develop concerning what persons and what entities other than states could themselves bring and support claims based on the alleged breach of international law rules. This was a case where the ICJ was able to give a bold and even innovatory opinion with remarkable effect. This opinion was arguably one of the most important ever made by either of the courts. The advisory opinions rendered by the court in its early years reflect both the relevance of the court's universal aspirations, the value of its integration into the United Nations system, and the trust that states had in the wisdom of its decisions. The actual workload of the court fell a little in the second decade, but included still some difficult cases and 2 judgments about Southwest Africa, one in 1962, when by a slim majority the court upheld its jurisdiction rejecting preliminary objections, and the other in 1966, the judgment which proved very damaging to the court. Perhaps I will say a few words about this 1966 decision. The case, in fact, began in 1960 when both Ethiopia and Liberia made identical applications alleging that South Africa, as the mandatory for West Africa, had in several respects failed in its international legal duties to the United Nations as successor to the League of Nations. The court decided that the identical applications be joined as being in the same interest. So the parties were limited to suggesting only a single judge ad hoc. I mean, the applicants, of course, South Africa was also entitled to appoint judge ad hoc. As I already said, in 1962, South Africa's preliminary objections were rejected, and the court upheld its jurisdiction. The arguments on the merits were heard in 1965. However, in the meantime, the membership of the court had changed owing to irregular elections. And the Australian judge, Sir Percy Spender, former foreign minister and ambassador to Washington, had been elected in February 1964 the new president of the court. The court sat only with 12 elected members, since Sir Muhammad Zafrullah Khan was persuaded by the president to recuse himself on account of his serving as president of the General Assembly in 1962-1963. In fact, Sir Zafrullah Khan was vice president of the court until 1960, but then he lost elections against the Japanese candidate. So he was then appointed as permanently in New York, and 3 years later re-elected to the court, the only judge who left the court and returned in the 73 years history of the court. Judge Bustamante Rivero did not sit because of his illness, and Judge Badawi of Egypt died in August 1965 during the summer break in the long hearings which opened, can you imagine, in mid-March 1965 and closed in late November 1965. As I said, in addition, there were 2 judges ad hoc, one jointly chosen by Ethiopia and Liberia, and the other by South Africa. The parties expected in 1966 a judgment on the merits. 7 members of the court, however, now returned to the preliminary objections and were minded to hold that the applicants had failed to establish any legal right or interest in the subject matter of their claims, and that their case ought therefore to be dismissed. Another 7 members were opposed to this course, and only the casting vote of the president ensured a judgment ending the cases by dismissing the claims on the ground of lack of standing of the applicants. The decision surprised even the respondent and was bitterly contested both inside and outside the court. The case demonstrates with great clarity that judging is an art rather than a science, that it can be agonizingly difficult role to fulfill. The timing of this decision could hardly have been worse. It was indeed to produce a relative famine of cases in the 70s and to fewer calls at the 3rd United Nations Conference on the Law of the Sea for the creation of a new court, the International Tribunal for the Law of the Sea, to deal with the maritime cases which alone were within the remit of the conference. But many advocates of a new court at the conference saw it rather as a competitor and alternative to the ICJ. This was a crucial time for the court and not at all an easy one. This decision was heavily criticized by a number of delegations during the General Assembly in 1966, had inspired some actual hostility to the court, and as I said, this was also reflected during the 3rd United Nations Conference on the Law of the Sea. luckily, shortly after the South Africa cases were concluded, the court made a good decision in still one of the most important of cases, the North Sea continental shelf cases, with Denmark and Netherlands on the one side and the Federal Republic of Germany on the other. The case was brought by special agreements concluded between these three countries. The task given to the court was potentially of broader general significance than this particular matter of the North Sea, for the case was about continental shelf boundaries. And there were at the time many such other boundaries that were undetermined and potentially disputed. The court, however, was not asked to delimit the disputed boundaries, but to give an answer to one question, disagreement on which had brought negotiations to a halt, whether the law required the employment of a principle of equidistance, which Denmark and the Netherlands wished to espouse, or a looser notion of equitable principles which Germany advocated. So the court was requested to decide what principles and rules of international law are applicable to the delimitation as between the parties of the areas of the continental shelf in the North Sea, which appertain to each of them. Denmark and the Netherlands had ratified the 1958 Geneva Convention, which espoused the equidistance rule, but Germany had not. And the court, in this judgment, made several pronouncements on the formation of customary international law, which are of continuing validity. And the decision of the court on the merits, which favored the German thesis, is still one of the most cited and respected of the court judgment. Indeed, the main decision was incorporated into Article 76 of the 1982 UN Convention on the Law of the Sea. But I have to admit that more recently, the court, when applying this provision, speaking about equitable result as an outcome of negotiations between the parties in order to delimit their boundaries, has resorted to the use of equidistance as a first step in maritime delimitation. As I already stated, in the 70s, there were fewer cases brought before the court, and it was in particular in the second half of the 70s when between 1974 and 1978 there was only one judgment rendered, a short judgment in the Aegean Sea continental shelf case between Greece and Turkey. And the court concluded that it was without jurisdiction because a press communique from the meeting of the two prime ministers in the analysis of the court did not constitute an international agreement in which Turkey would have consented to the court's jurisdiction. And it took further a year and a half before the court was in a position to render another judgment, and it was in 1980 in Tehran hostages cases brought by the United States against Iran, or Islamic Republic of Iran. It was important that in the late 70s, however, it seems that some African countries, having, if not forgotten, pardoned the court, showed confidence in the court because they concluded special agreements by which they brought jointly cases before the court. The very first such special agreement was concluded in 1977 between Tunisia and Libya, and it again concerned the delimitation of the continental shelf. And the court decided the case in early 80s. Another special agreement concluded between African countries was a special agreement in the early 80s concluded between at the time of signing of that special agreement, Upper Volta, which in the course of the proceedings changed its name to Burkina Faso and Mali. Moreover, these two countries decided that the case be heard by a chamber of the court, not full court of 15 members, but 5-member chamber of the court, which was formed for that purpose in accordance with the statute of the court. Of course, this was not the very first chamber case in the International Court of Justice. 1 or 2 years earlier, a chamber was formed upon request of the United States and Canada, which had problems in delimiting continental maritime boundary in the Gulf of Maine. And while delegations were ready to agree, the text of the agreement encountered difficulties in the US Senate, which wished to introduce amendments into the text. But these were not acceptable to Canadian parliamentarians, so the two governments found a way how to resolve this difficult situation, bringing the matter before the court, agreeing in a special agreement that a chamber be formed, and it was in fact the condition that the court respects the wishes of the court, of the parties, as far as the composition of the chamber is concerned. The 80s were years of renewal of the court. Very important judgment was rendered first in 1984 and then in 1986 in the case brought by Nicaragua against the United States concerning the armed activities in and against Nicaragua. United States challenged jurisdiction of the court, but the court upheld its jurisdiction. The case demonstrated that the court can provide protection in legal terms of smaller countries in their disputes with major powerful countries. The political changes which Minister Vedrin mentioned in late 80s, early 90s, also had a positive impact on the court. Because until 1989, 1990, countries of Central and Eastern Europe from a socialist bloc, they did not recognize jurisdiction of the court by a declaration. They occasionally accepted jurisdiction in compromissory clauses contained in multilateral treaties, not making reservations to these clauses. But with political changes, some of them started to revisit their approach to the court. And the very first country from Central and Eastern Europe which recognized jurisdiction of the court was Poland in 1990, when foreign minister was Professor Skubiszewski, a great Polish expert in international law, later also member of the curatorium of the Hague Academy. And subsequently, several other countries from this region followed, like Estonia in 1981, Bulgaria in 1992, Georgia in 1996, and 3 or 4 other countries after 2000. But also it was in this period that the first 2 cases from this part of Europe were brought before the court. One was rather tragic and sad case because it was a genocide case brought by Bosnia and Herzegovina against Federal Republic of Yugoslavia, Serbia and Montenegro in March 1993. The other was more technical, but still interesting case, brought by special agreement between Slovakia and Hungary concerning the construction and operation of the dam project in Gabčíkovo and Nagymaros. In the 90s, another major case was brought from Africa, this time by Cameroon against Nigeria. It concerned a very long disputed boundary over 1,500 kilometers, which had to be determined by the court, and also the issue of sovereignty over the oil-rich Bakassi Peninsula, which was administered by Nigeria, and also the maritime delimitation. The court decided this case in 2002, adjudicating, among other things, that based on applicable legal principles, including uti possidetis, Bakassi Peninsula, in fact, falls under the sovereignty of Cameroon. I'm mentioning this case because United Nations and its Secretary General perform a very useful role in implementation of the judgment. Kofi Annan convened the two heads of state, President Biya and Obasanjo, shortly after the judgment was rendered. In fact, I think they were informed well before the judgment was delivered of the intention of the Secretary General. And the United Nations established a special commission between Cameroon and Nigeria assisting with the implementation of the judgment. It took quite a long period, but at the end the judgment was fully complied with, and Nigeria withdrew its armed forces and administration from Bakassi Peninsula. So the United Nations played an important role in the implementation of that judgment. The court, having been the court of a universal jurisdiction in terms of subject matter, because jurisdiction of the Law of the Sea Tribunal is limited only to the matters governed by the United Nations Convention of the Sea, the Code, International Court of Justice being the code of wide jurisdiction in terms of subject matter which can be brought, of the disputes which can be brought before the court, has to deal with now a variety of cases, not only with traditional maritime delimitations or territorial disputes, but also with cases relating to use of force, including cases on human rights, environmental cases like aerial herbicide spraying case between Ecuador and Colombia, which the court was ready to adjudicate in 2014, but shortly before opening of the proceedings, the two parties reached an agreement and thanked the court for its role in assisting the parties to reach such an agreement, because they expressed the view that without court involvement, it would have been difficult, if not impossible, for them to agree. And the case was discontinued while the agreement allowed Colombia to continue an herbicide spraying of coca plantations in the south of the country under strict conditions, while also providing for some compensation for the damage caused by previous activities in the territory of Ecuador, although it was not with the admission of liability, it was construed as a contribution to social and economic development of the two provinces. The court remains busy. It has 17 pending cases in its docket at the moment, and this situation has been, in fact, since late last century, early last decade, that the court had in average between 15 and 20 cases in its docket. Despite the fact that the court accelerated its work and has now been for more than 15 years working in parallel on 2 or sometimes 3 cases. Perhaps there might be some criticism that proceedings are long, but it would be a mistake to compare proceedings before the International Court of Justice with proceedings in national courts, supreme courts. The court is not only the highest United Nations court, but is also a court of first instance. The court has to deal with evidence to establish factual situation and then to apply law. And there is no appeal against court's decisions. So the court has to be careful not to commit any mistake, because there is nobody to commit any possible mistake. What is the prospect of the court? As I said, I have no doubt that the court will remain busy in the decades to come. The court has 17 cases pending, but we know of some special agreements which have been signed but not yet ratified, and on that basis some cases may be brought. For instance, a special agreement between Gabon and Equatorial Guinea. Or there is a request for advisory opinion under consideration to be formally undertaken by the General Assembly. It's still discussed within the African group in the United Nations, relating to immunities of head of states and high-level officials from criminal jurisdiction. The item is on the agenda of the General Assembly. But what is still a little bit unsatisfactory is the fact that states, despite their proclamations that they are for the world order based on rules, rule-based order in international affairs, they are still not yet, many of them, willing to accept the court's jurisdiction. In fact, in my view, there has been, in the long run, a decline in the willingness of states to accept the court's compulsory jurisdiction by accepting broadly by a declaration. In 1934, there were 42 countries out of 58 member states of the League with such a declaration. It's 72%. In 1948, 34 out of 59 members of the United Nations, it's 59%. But today, 73, so optically there was increase, but out of 193 member states of the United Nations, so in terms of percentages, it's around 38%. And despite the appeals on which the states are able to agree, like in the World Summit Outcome Document of 2005, or a report and document adopted during the high-level event on the rule of law in the United Nations in 2012, calling on states which have not yet recognized jurisdiction of the court to consider the possibility of making a declaration accepting its jurisdiction. Very few states have done so. In fact, since 2012, maybe 4 or 5, no more. So, while diplomats elaborate nice texts of resolutions in the United Nations, what is missing is a follow-up, implementation or reaction to these calls. And each and every state which claims to be in favor of the rule of law, in my view, should be ready to accept the jurisdiction of the principal judicial organ of the United Nations. If not, without any limits, at least for particular categories of disputes, because this would be a concrete action when they preach rule of law. And basically all member states of the United Nations declare that they are supporters of rule of law in international relations. This brings me to the end, but I'm still willing to answer a few questions. I think if my watch is not wrong, we may have still some 6 minutes, Monsieur le Président. So the floor is open for your questions.